Hi, I'm Marty Pohl with Hessig&Pohl Law Office. If you're watching this video, it's probably because you've just found out that you have to be a witness in a deposition. I know you're sitting there thinking, what is a deposition? What kind of questions will I be asked? How should I answer those questions? These are the types of things that people wonder, and these are the types of things that make people worry about giving a deposition. My plan here is to give you information that will help alleviate some of that worry. I'm going to give you 7 tips here today that'll help you feel very confident and comfortable when giving your deposition. Now, my first tip is understanding the point of a deposition. A deposition is an out-of-court statement that can later be used in a court proceeding. Now, attorneys like to use depositions because they get a sneak preview of what the testimony will be prior to a trial. Attorneys on both sides will take depositions so that they can hear what a witness will later testify to. Now, the attorneys will be using the testimony in that deposition to determine the strengths and weaknesses of each side's case. They're not only going to be looking at what is said, but how it is said. So it's important that not only is your testimony strong in content, but how you deliver it. Argumentative witnesses, witnesses that have tough times clearly stating their points, those are going to be viewed as weak witnesses and witnesses that will not present well at trial. So you want to be as strong a witness as you possibly can, and some of the tips that I'm later going to give you will help you be a strong witness. My second tip is preparing for the deposition. You should find out where the deposition will be held, which attorney will be taking the deposition, and how you should dress. Consult with your attorney prior to the deposition to find out all of these things. You are going to be judged based on how you present, so appropriate attire is going to be very important. You should consult with your attorney in regards to any statements that have been made prior to the deposition. Oftentimes there will be written statements that have been made. There could have been statements that were given prior to the litigation process altogether. So you're going to want to review all statements that you have made prior to the deposition so that you're aware of their existence, and you're going to want to make sure that you stay consistent if in fact those prior statements were true. If you were a plaintiff and this is your deposition, you really oftentimes only get one opportunity for your voice to be heard, and the deposition is that. It really is like an audition to see if your case can get settled prior to trial. My third tip is understanding the format of a deposition. The deposition is going to be an out-of-court statement, usually held at one of the attorney's offices, where the attorney will ask you questions and you will be expected to answer those questions. Now, it's important that when answering those questions, you try to remember 3 key things. You're going to want to be confident, you're going to want to be calm, and you're going to want to tell the truth. You're going to be sworn under oath, so you're going to be obligated to tell the truth. But you want to tell the truth not just for that reason. 1, telling the truth is going to help you remain confident and calm. But 2, if the attorney can prove that you've given a statement that's been untruthful, they can use that later against you in the trial. I'll give you an example that has happened to me in the past. I had a client that had a criminal history, and they went through the expungement process, but the case had not been completely wiped from their record. So the question was asked, have you ever been charged with or convicted of a crime? And the client, thinking that the case had been wiped clean from their record, answered no. Well, the attorney was able to see that the client had actually been charged with a crime. It was public record and they had access to that. So then later, in the deposition and later in the trial itself, the attorney was able to say, now, sir, were you lying then or are you lying now? Were you telling the truth then or are you telling the truth now? When an issue like that presents itself in a deposition and then later on in the case, a jury's going to look at an issue like that and say, well, if this person's willing to lie about something very small here, then they'll probably lie about other things. And maybe they'll lie about more significant issues in your case. So it's best practice to tell the truth in your deposition, even if you feel like it's something that could hurt your claim. My fourth tip is to listen to the question. I oftentimes advise my clients to pause after a question is asked for a couple seconds before giving an answer. Being too quick to answer the attorney's question oftentimes leads to the attorney and the witness talking over each other, which can lead to a sloppy deposition, and it can also lead to the witness giving testimony beyond the scope of the question itself. And that's bad for a couple of different reasons. One, it leads to a deposition that doesn't make a ton of sense when you're not answering the question that's asked. But two, and this is probably more important, you can give information that the attorney wasn't really looking for before you had offered it up voluntarily that could lead to more questioning that could really hurt your case and hurt your position. My fifth tip is that you should understand the question. You cannot be a good witness if you don't understand the question that is being asked. If you answer a question, the attorney will assume that you understood the question that they were asking, which can oftentimes lead to confusion if you didn't understand the question, and it can also lead to a misleading deposition transcript down the road. Attorneys can often ask compound and confusing questions, and sometimes will include legal jargon in their questioning. It shouldn't be an embarrassing thing to ask for an attorney to rephrase something or to let them know that you don't understand the question that they are asking. So if you don't understand a question, it's always best to ask the attorney to either rephrase it or ask it in a different way. But regardless of what you do, you need to let somebody know that you do not understand the question. My sixth tip is that if you don't know the answer to a question, just say so. You have to remember that this is not a memory game and it's not a quiz. Oftentimes, attorneys will ask you questions about things that took place years ago or things that they already have in their file, and they're just asking to see if it's something that you remember. If you don't remember, say you don't remember. Your attorney is going to always prefer I don't remember or I don't know as opposed to a guess or an approximation. My seventh and final tip is that the best answers are the answers that are short and sweet and to the point. So long as your answers remain truthful, my favorite answers are yes, no, I don't know, or I don't remember. So those are my 7 tips for giving a good deposition. If you have questions about that or any other legal matters, I can be reached at www.hessig&Pohl.com, or you can call me at 502-777-1111. I'd love to help.